I think that we can now continue with our second phase of the first session. So I invite Miriam Begazia to take a seat and to put us in. Yeah. Thank you for your help. You're such a good colleague.
Yeah.
Thank you.
These chairs are not really convenient.
I have one of those.
I'm really sorry.
Okay, good.
Yeah, nice to meet you, Ayman. I'm so sorry because we had to continue with you. We wanted to make some changes, but our commentator is not here for the next session.
It's good. Sorry that I was late.
Okay, so now we have Miriam Begadze from Central European University, who will present us her paper on the topic the judiciary in modern times.
Yeah. That's a big topic, but yeah, I will try to look at this issue from a certain perspective. First, I will say that I'm Mariam. I come from Central European University. It's my second year of studies, and I'm doing a research on socioeconomic rights education and how it affected separation of powers in 4 jurisdictions. That's the current state of affairs, but we will see how it goes. And but my topic today is not specifically related to my research. But it's some observations about things that I've been working on recently during last year. We know debates that are going on about what is the right limit of judiciary engaging in judicial review, what is the long-term result of it, and people are writing about Hungary, Poland, how maybe strong courts affected their long-term institutional standing. People argue that in countries where there are no rotation of power and fair election systems, it's really hard for strong courts to really maintain their power throughout time. So there are many views. There are still research saying that on a general level, it still has been successful and courts have managed to maintain their power. But my way of looking at it is just to locate theories. We can say that there are, for instance, Ginsburg's theory about insurance theory about political powers wanting the judicial review as if they are not strong enough, if they have the risks of losing power, then insurance theory tells us that even for political branches, it's convenient for them to have judicial review because if they lose, then it's ensuring that they can still have some stake in the political game. There is also another theory from Hirsch telling us that it's again a way of preserving power for elites. So it's within these theories we can say that there is not much space for judicial agency. What courts can themselves do to build up their institutional legitimacy. So their contribution to their own fate. So the question that I will start by locating this a bit in these theories is that are courts completely dependent on political circumstances, or can they be active, not passive actors, but active in terms of shaping their own institutional security? And for this, we can also say that there is enough theoretical debate saying that even if we are talking about judicialization of politics, we are talking about courts that are constrained by rules and methodology. So it's going to be more difficult for judges to operate in the same way as political actors do, because they are still constrained by laws and methodology, and there may be interpretation methods. In the US, an originalist judge will have difficulty putting their preferences into their decisions if this conflicts with his own philosophy. So when we're talking about courts, still it's sometimes it becomes easier to see when they really become political actors, because we see that they are deviating from their own philosophy or the rules. But we also have extreme examples, and for the extreme example, I can say, for instance, I can think of Indian Supreme Court when it made socioeconomic rights justiciable, despite the fact that in the constitution there was an explicit norm against it. So in these extremes and general positioning of judiciary, how it functions, and what are the theories, we can also first discuss Rook's ideas about how South African court managed to maintain its institutional security, and he talks about mix of principle and pragmatism, and brings up examples how the South African court was very strategic in its dominant party system to still remain principled, but in a way managed to deliver very principled, remain principled, but at the same time, when it was necessary, it a bit compromised on principle with the purpose of maintaining institutional security. And three cases that we can mention very briefly, just brief idea why those can help us understand what South African court did, is the first decision it dealt with, death penalty case, Makwanyang case. In this case, the idea, the perspective is that the public was really against. The public was not very favorable to the abolition of death penalty, but in this case, political branches would have accepted this decision because it was a controversial issue, and the court was a safer, more convenient place to decide it. So in this case, the court was could exploit this political circumstance of having some kind of support from political branches, and despite the fact that the public may have been against it. So in this case, it wouldn't have to deal with backlashes as a result of this decision. So it was, as Rooks frames it, it was a strategic decision by the court. The other case is a treatment action campaign, in which it was the other way. It was really painful for the government to admit and change its own policy, which it was very firmly defending denialist policies that the HIV/AIDS didn't exist and the problem was not there, but the public was really supporting it, and through the campaigns of treatment action campaign, by the time when the court was deciding it, already different regions of the country had permitted use of these medicines. So the restriction of, so in this case, when the government had the restriction of drugs, nevirapine, and the decision went against the government, still the court had a lot of support of the public. So just to say, in one case we had the support of the party, and the other case we have the strong support of the public, and the court manages to be very strategic. And the other case, which Rooks mentions as the court compromising a bit on principle, is the case in which there was election and the government decided that only one form of identity documents would be accepted for voting. So the survey showed that 20% people wouldn't be, if they didn't change their identity documents, they wouldn't be able to vote. And also, if you really saw which part of the population was affected, it was the supporters of the previous apartheid government. So on this decision, it was the Rook says that it seems that the court saw this way, that the stakes of institutional security, the government may have had really harsh reaction on it, so it could suffer from backlashes. So the court in this case decided to say that yes, this is maybe a way to exercise the right to vote. It didn't say it was a limitation of right to vote, and it used a very lower standard of rationality rather than reasonableness. So Brooks argues that maybe this was a good decision for the court to not really give up on very significant principles, but modify its principled approach, because it was a way for the court to, in this time, build up its own institutional legitimacy. And with this example of South African case, I want to see if something similar was happening in Israel, but if Israel's Supreme Court, in two cases that I saw and thought was interesting, was doing a similar thing, in which the court itself, through some techniques, decided to wait until it managed to accumulate enough institutional security to decide cases in a certain way. And here I think that our premise should be not just general idea that we need activist courts to survive political backlashes, but what is our normative goal? Do we want the institutional legitimacy of courts as political actors or legal actors? And if we want them to maintain this security as legal actors, then we are talking about diffuse support of the court. So it's not the public liking their decisions as such for them, but they should see the court as a desirable and reliable institution that we may not even rule in favor of them, but in a long run, it's an institution which is constrained by law and is so it has this legitimacy in public, that law and politics is still, even if courts decide really highly politically charged cases, that it's still a legal actor and not a political one. So so from this perspective, we can probably distinguish between two kinds of cases. Again, cases like treatment action campaign, in which we're talking about direct support of the public, or right to food case in India, for instance, in which it's really hard to go against court, whose decisions are quite popular in public. Because in one case it was the court really contributing to resolving the issues with health emergency, and in the other case it was famine which was happening. The court managed to use the stocks of food to eliminate some very harsh results. So there will be cases in which an institutional failure or crisis which goes through the whole nation is so evident that the courts will, with this direct support of the public, will not be as vulnerable as in other cases. But I think there is another line of cases in which there even may be neutral principles to decide, but the courts are still very vulnerable in terms of institutional security. And here I also wanted to go back to an old school, not old, but process school, which tells us that even though the law is indeterminate, the way to deal with it is, as much as we can, look for neutral principles. And the convenient way to think about this process school is to remember Wechsler's approach to Brown versus Board decision, in which Wechsler argued that even if the decision has favorable results we all like, how they do it and how they reason should be based on neutral principles. And in the Brown versus Board decisions, we know that the argumentation was really related to the effects of segregation in terms of how hostile it is to Black people, but he was arguing that a better way of dealing with the issue was saying that at least have a neutral principle, as the government not having the right to restrict freedom of assembly, or freedom of association between these groups. So even if Wechsler himself has questions about his own solution, but the idea is clear. We have to look for neutral principles. And what I'm thinking is that even if the existence of neutral principles is not enough because the cases are very highly political, then probably this idea of neutrality at least has to be a guiding one. So what process school tells us are important ideas as the courts need to be able to maintain appearance of neutrality, and they need to do it through some distinction of law and politics, and still be capable of making a difference when political branches are failing, but only through law and principle. So the two cases that were interesting for me from the Israeli Supreme Court is, one is Ressler case, and I will describe shortly how it was decided, and the other one is Maccabi case. So those are on completely different issues. The first case was about a long-standing controversial political issue in the Israeli society, that there is minority ultra-Jewish minority and yeshiva students, which are the students studying at the religious institution, they get exemption from military service, despite the idea that in Israel the law requires everybody to serve some period in military. And this law is very controversial issue because the political party that is associated with this group is, although it's a very small minority, it still has important leverage in political field, because government coalitions a lot of times need this party support to actually have governments, be able to have constitute government. And because of this, for a long time, the issue for the court, it was difficult to decide it. And in the last decision, when it actually said that this was violation of equality, that only one group gets blanket exemption and not the other ones, in this last case, it starts the decision by saying that we are discussing this issue 8 times, and it's been here since the creation of the state. And just to say that the last decision said it was a violation and of the right to equality under the basic law on dignity and liberty, but we need to see what happened before, and I will try to make it clear so that we understand what the court got to the final conclusion. So in the beginning, the court was more deferential, and we will discuss 2 cases before the last decision. So in 1998, the court said that because this exemption was decided by the minister, the court said that the issue now, because of the number of exemptions and the number of students who were able to use this privilege, became so large that the issue had to be decided by Parliament, Knesset. So it used its doctrine of primary arrangement, so issues when quantity means quality. So when we're talking about such an important issue, which is already not a very administrative exception and like marginal decisions about hundreds of people, but thousands of people, then the parliament has to be the one which, through deliberation, decides this issue. So this was the 1998 decision, and the Knesset complied with this decision by enacting a law. So it enforced the court's decision and adopted a law which now on this statute level said that there can be exemption. But the interesting thing was the law also contained incentives for the exempted students to actually still participate in the military service, and that was a way to address the concerns about equality already expressed in this against this policy. And then in 2006, the court again discussed the issue, the law now, and the court said that as the law stands now, there is a violation of equality because we see that a lot of people still get exempted and it's blanket, but it said that maybe we need still time to see whether there is a genetic defect in the law or it's a matter of implementation. So with a bit contradicting description of the issue. It, on the one hand, says that there is violation of equality, but it says that we need to have time to see whether it's a problem of the law itself or implementation. And again, it is deferential. And as we said in 2012, then the court finally said that yes, we waited enough, and we can now say that it's not about implementation, but the law itself is violating equality. So for me, it was interesting how the court dealt with it, because it seems that argumentation is quite consistent. Still, you can see that it's not it's not telling us one precedent or overruling it or changing in a very. So it's, of course, it's more deferential, but still it's a linear line of argumentation that in the end turns weak form review to a stronger one. And also in this period, we see that the first decision that the court makes is enforced by the Knesset, so it actually says that, okay, if it has had to be regulated by Knesset, and we will do that, and it did it. So in literature, very often we also see people writing that with every decision that is enforced by government, the institutional security increases. So this can be seen as a strategic way of a court depoliticizing the very political issue and very slowly making it, changing its nature into a legal claim. Another case that we can mention is, as I said, not about the same issue, about a similar issue. It's about right to. It was related to right to health. It was a case between health funds and the government, because there was not a mechanism for updating health index, which so health funds and government health funds are intermediaries between government and the health providers, hospitals, and so on. And health funds were claiming that the fact that the law does not guarantee updating of the health index leaves them in the situation in which health costs increase, but they don't get enough funding to provide the same quality service. So here too, the court discussed the issue 3 times, and in the first decision, it said, because there was a statutory body that, like government statutory body, that recommended that this mechanism had to be changed. In the first case, the court says that yes, there is this recommendation which has to be taken into account, but it can't instruct the government to actually update the mechanism. In the second decision, the government already considers the recommendation but doesn't change anything, and the court says that it's fine because the government complied with its own decision, but it says that budgetary restrictions cannot be brought as an argument against a right which exists on a statutory level. So if you have to provide these services and it's in the law, it's not constitutionally required, but it's in the law, then you either have to change the law or provide the service. And then the third time, when the issue comes back to the court says that okay, now enough time has passed, nothing has changed, and you need to, of course it doesn't actually instruct the government to allocate certain funds, but it says that in 6 months you have to change the mechanism. So here I think it's, in a way, is also a similar way of slowly moving from weak form review to a stronger one. And in this period, you see that in this dialogue, the government enforces some of the instructions that the court has. So in between, the court perhaps manages to build up its own institutional security more. So I think from these arguments, I want to emphasize that judiciary does have agency and is not completely dependent on political circumstances. And even if my insight about is that they need to be strategic and maybe embrace their own political dimension, this should be in a way that it doesn't portray them as political actors, but still as legal actors. So they consistently follow their arguments, but if they do not put through their own policy preferences in the very first occasion that they get the case to court, maybe that's even a way of portraying their this appearance of neutrality, that they really got there through legal arguments and not political ones. So in this sense, maybe even deference fits in the context of the ultimate principled position of the court. So even if courts survive attacks because they act strategically, the focus needs to be on them as judicial actors, as I said, and there can be legal techniques to do it. And some of the legal techniques that we saw in the cases may be that this primary arrangement argument, when courts, if something that they may later think is a violation of a right is that decided through a government decision, the first thing before they issue a more politically controversial decision, perhaps they can first require that this goes through a deliberation on a higher level, and maybe in this process the problem is solved through a more institutionally secure way. And something similar was in the second case, for instance. The court first used the argument that when you have a law, you can either have a political deliberation and take away some of the rights that you granted, which will be more difficult for the elected branches to do. So you can actually think of judicial actors as having agency and having also legal tools to postpone making a very politically charged decision. And again, going back to this, I think this way of operation is a better solution to having two extremes of courts not making principled decisions when their institutional security may suffer. As some scholars may say that maybe in the case of Hungary, it was better that the courts were not strong as they were at some point, so that they would maintain their legal standing now. But it's also against the other extreme, in which courts just have to be deferential all the time. So here we are again talking about diffuse support, so the courts remain not political actors, which could be the case, for instance, in India. A lot of scholars say that the courts transformation in terms of law and politics, that the courts becoming interfering more and more in political spheres. It didn't stick to very constraining understanding of the law for the judiciary itself. So this perspective is perhaps an addition to, and this is not only my observation, this is generally Rook's argument in his most recent book, in which he says that a way of looking at judiciary only from political preservation theory and insurance theory is wrong, because actually courts have agency and they can do things, and also what it matters what kind of societal understanding of law and politics is. So how they see the courts themselves when they when they are in support of the court, how do they support it as the institution which is legally constrained, or as the institution that is just delivering decisions that they like.
Yeah, I believe we are out of the time.
Okay, I think we are also.
Yeah, I didn't measure the 15 minutes because I was convinced that all of you are going to take care of it, but I was wrong. Uroš, please.
Good morning, all of you. Good morning, Miriam.
Good morning.
I would like, firstly, I would like to say that even though that I have some formal remarks, I'm very happy and satisfied for having read your paper, because of my PhD topic, proportionality, which is very close to your topic of today. Part of my PhD is about judicial review, so I learned a lot about Herschel and legal process theory. I have to say thank you for giving me a chance to participate today, to learn something new. And what I would like to say is that I think that the important thing, the most important thing, is that there is ongoing justice.
That's always a difficult word.
Yeah,
Justiciability. Judicialization.
Judicialization of politics, especially in the countries which are pre-political societies, such as Serbia and Georgia, because of their communist past and omission and absence of democracy before that. And that it is very important to have active courts in order to create and maintain democracy and to create democratic institutions. So it's all of me.
Thank you. Now let the discussion begin. Do you have any questions?
I have questions. So, okay, I already asked you many questions since we know each other's work, but in this context, I would actually like to agree with Roche, your commentator. So I think that I don't agree with you completely. In some contexts, yeah, but not. You cannot apply your insight to all of the countries. First of all, I don't agree that, as you know already, Constitutional Court is not just a legal actor. So you have to, by now, you have to admit its political or quasi-political nature. And nowadays, having this broad range of legal matter that goes to constitutional review, you cannot say that I think that putting those questions very politically sensitive questions into judicial review definitely should be done by principals, but I'm just not sure that putting them into principles or under principles will actually deprive them from their political nature. So in that sense, the question remains political, whether you decide it now or you decide it 10 years from there, like it remains political, and maybe it will help the court to remain its neutrality or to build its institutional reputation, but that can also have a serious backlash. Now I'm talking just from our own experience, Serbian experience. So, as I was mentioning, Serbian Constitutional Court is famous for its strategy of avoidance and delaying decision making. So, I don't think, in that sense, it depends. Like, what is the goal behind this strategic decision making? If the goal is to just remain its institutional neutrality, then okay. But if the goal of constitutional court is completely to leave those questions to other branches of government and be not just deferent, but also be completely out of the legal sphere, as it's happening in Serbia, I don't think that's actually a good approach. We had that case, as I was mentioning you, so Uroš, you probably know the paper. Professor Violeta Beširović
Yes.
wrote a paper about Bristol Treaty,
Yes.
and I actually think that her claims were very similar to Mariam's claims in the sense that she said, yes, the question of Bristol Treaty should remain within political branches, but the court should have decided it within legal principles. So basically, her argument was that political agreements such as Brussels Treaty should not be subject to constitutional review, but the court still should decide it and dismiss the case on legal grounds. And in that sense, I agree with your insight. But on the other hand, I just think it can have serious backlashes in developing democracies such as ours. And I have a question. So. Thinking about that theory, do you think that the US Supreme Court has ever shown this kind of strategy? And how would you define the Obergefell versus Hodges case, that's same-sex marriage case within your theory? Because I think it's completely the example of completely the opposite, right? As we discussed, the lack of legal principle within that decision.
Yeah.
Thank you, Theodora. Mayor has also.
For the presentation, which is very interesting. I think that's just a general comment. I think you accurately represented the state of the case, which I know. So it was very interesting to see. I have a couple of questions. The first one, for sure, emanates from my lack of professionality on the matter, but can you say a few words about what you take institutional security to be? Because there seems to be a kind of presupposition that this is what we're aiming at. And also, that is a question like, is this the only goal that such an institution as Supreme Court and so on, or a constitutional court should aspire to? And secondly, I wasn't sure about the techniques which you discuss. Do you take it to be an advantage of the, as they say, the splitting technique, using specifically preliminary argumentation, namely saying, this is not yet right for judicial discussion, or this is an academic question, such as often has been the case with the Israeli Supreme Court? Like, do you take such mechanisms to be positive, or do you just reflect on the fact that the constitutional court is using? Because obviously that also relates to the previous question, because the question then becomes, what is the goal of the constitutional court? And in that sense, I think.
Yeah.
Thank you. Yeah.
So my question to you is about how do you differentiate between judicial activism and judicial overreach? For example, like in India, like you quoted India as an example. So and you also cited the criticism of the Supreme Court because of its acting like an executive rather than a court. Because Supreme Court puts itself into the shoes of the executive and it reviews everything which is political, and sometimes it has led to economic slowdown of the country also because of certain policies where certain people challenge on the ground that it's unfair or it's something which is arbitrary. The Supreme Court intervenes. Until the time Supreme Court hears the entire case, the value of a trade deal or of anything reduces its economic value. So it has also, in fact, been very much against the national interest when it comes to economics, and that's why Supreme Court have been criticized. This is my first question. And my second question to you is, do you think when the court become too activist, and when a court become too activist, then it shifts the accountability that the government have towards the people, and it shifts it from the government to the courts, and people, rather than demanding something from the government, they move more toward the courts, and the courts are unable to do justice to the people because, and in the same time, the government just shrugs off from its responsibility. For example, recently in India, when the GI case was being decided, the government came and the government took the stand that they don't have any stand, and they left the court to decide on the validity of GIs in India. So this was very unusual for a government to not take a stand in a court. So do you think that the court on certain issues when it decides on its own, without taking into the picture what the government has to say on it, in such situations, the accountability that the government has toward the people gets gets diminished and people move more towards the court than to the government?
Yeah.
And
In fact, I would like to join the question or the doubt of Meyer. Because when you see, as far as the strategy of, as it was named here, avoidance of deference is concerned, when you see a possible solution to the problem, I see a huge violation of right to justice. Because when people have to wait for the judgment years and years, that leads, in my opinion, to the loss of legitimacy of the court, and that is, I think, it's a vicious circle. So, don't you think it is problematic to use this strategy, even if it works, like in particular cases, but in a general view, I think it might be really dangerous. That's the case in Poland,
Yeah.
I must say.
As the concern was expressed by all of you, maybe I will start from here. Whether I see it normatively a good idea to do this, or whether it's an observation. I think I cannot completely say that in Israeli situation it was the best strategy, because I think I need to know more to locate this whole thing in other things that the court does, because in Israeli case it's different how the court itself became a constitutional type of court was through a decision, right? It was a constitutional revolution. So a lot of scholars say that after the very activist decision in which it got the power of judicial review, it became more conservative, and there are always some things to trade off. Sometimes you cannot be all the time the same way. Activists, especially when in Israel, for instance, you can also say if I'm completely right, but I think it's widely accepted that the court doesn't have huge public support. So you need to sometimes as a court, be strategic in terms of what are there at stakes. If there court packing as a result of this, then if the court cannot have the same standing and even have the same scope of review later, because also it's very easy to change basic laws in Israel. So courts, I do agree on a normative basis that the courts do need to be strategic, and you cannot it can be a bit naive sometimes to expect that it will always be inside the tolerance interval, as the scholars say, of elective branches. And we would like strong courts, and I was myself, during my previous career, I was the litigant, so I have this in court, so I always wanted the court to be activist all the time, but in reality I think it becomes much more difficult to always follow the same path, and sometimes you have to think what are the institutional things that you have to be a guardian of more than some other things that you cannot trade off. But my view of it is that you shouldn't trade off. The courts need to try to trade off on principles as much as they can. So for me, Israeli decisions were an example of not saying one thing and then changing it because the political circumstances changed, but almost saying the same thing, but giving a different kind of remedy to it. Like in the first case, saying that deliberate, in the second case, saying I'm not sure if it's still proven, so I will need more time to see. So I think from a still non-expert view about Israeli law in total, my first reading of these cases is a positive one, as a good way of engaging strategically and still building up its own legitimacy through these cases, because in the end the court was the one who still managed to protect rights. And as for your mention of US Supreme Court, I would say that also probably debate goes in two ways, and you cannot apply the same arguments with new democracies and new courts that are trying to build up their institutional security, and I can also probably comment on that. Because there are some courts which probably have less threats of completely changing their structure, such as US courts, than the courts that are still, as was the South African court, for instance, after its creation and through this process that it went through. So sometimes there is more for courts to do to build its own institutional security, and maybe less for those with more tradition. And that's why I think that a decision like Obergefell's or abortion cases in US still doesn't mean that the first initial reaction would be court packing or completely changing their structure. So with institutional security, there are definitions which I couldn't quote now directly, but the two things that we're talking about is the court's ability to ensure that their decisions will be enforced, and that a harsher mechanism such as court packing or restricting their judicial review won't take place. And in this way, what the Indian Supreme Court did when it tried to protect itself institutionally when it decided the basic structure doctrine. So after the emergency and the loss of reputation of the court, this way of guaranteeing that at least its institutional security wouldn't be threatened by changing the things in the constitution that would take away, for instance, judicial review from Indian Supreme Court. So that also falls under these considerations of how courts can actually, through pragmatism and strategy, or through decisions like basic structure doctrine, to have some tools to maintain it. So I would also say that there is a huge difference between cases in which there would be neutral principles to decide, like the equality case in Israeli, and then when we're talking about Indian Supreme Court and its pro-poor judgments, which later in environmental cases even were contradicting its own initial beginnings of being pro-poor, because then it was demolition of slums without talking about the responsibility that the government may have, and this good governance court and the new functions that it gained through its own operation. I think there is a still a huge difference because in this case now we are talking about deviating from this normative goal of still maintaining this distinction between law and politics, because true, and it's not only me saying this, a lot of scholars are saying that when there are weak governments and the courts get the opportunity to be stronger, they actually do not support that the democratic process is revived itself, but this focus shifted to courts, maybe even be convenient for political branches because they delegate some of the responsibilities to the court, and the process goes in a wrong direction, in which the goal should be that not that somebody substitutes those branches, but those branches manage to correct their own mistakes through.
Thank you. That would be all for the first session. I would now like kindly to ask you to come with us